I don't know if I've got your bio. I've got a few notes here. There's lots I can say. I'm sure I've got that off you if you've got.
Don't worry.
So much to say. We could be here.
Myself if needs be. So
All right, are we underway?
You may start it now if you are ready.
Kia ora tātou. Do we have anyone?
Yes,
in
we do
Wellington?
have someone in Wellington. Yes. Yeah.
Hello there.
Hi everyone in Wellington.
Wellington's here, yep.
Hi, Wellington. Hi, it's Alison Douglas here. It gives my great pleasure to introduce Alex Ruck Keene. Can you see me? And can you see Alex? Hopefully they can. So Alex has an extensive bio, but just as a brief summary, Alex is a barrister at 39 Essex Street Chambers in England, in London, and was a very extremely helpful colleague for me when I undertook my mental capacity project in the UK in 2015. And essentially, he is so connected with this whole area of mental capacity law and practice. Everywhere I went, everyone asked, had I met, Alex Ruck Keene, and it covers just not only legal practice in his role as a barrister, but also in policy and in ethics, and he is also an accomplished academic as well. So that's the really amazing thing about Alex, and he's got a very interesting seminar for you today. He's also based not only as an honorary research lecturer at the University of Manchester, so when I went to the Manchester Law School, they all knew about him there, but he's mainly based through King's College London, the School of Law there, and he's part of this Wellcome Trust project, which he will sort of tell you about. But also, Alex has very interestingly been co-opted or commissioned by the Law Commission for England and Wales, and is really being instrumental in some of the proposals that are moving forward on the Mental Capacity Act in England. So he really does, we're very, very privileged to have Alex with his kind of wide background and really is a leading star in mental capacity law and practice in the UK. So over to you, Alex.
I think I'll leave then. I'm not sure I can live up to that. Thank you very much, Alison. Thank you very much for the invitation and also for hosting me so generously. So I'm actually here really to ask for people's help because I'm doing a big project, as Alison's mentioned, funded by the Wellcome Trust project on hard capacity assessments. Why people, both medical and legal people and judges, find some types of capacity assessment difficult. And then how do we think of more satisfactory ways in which to resolve them? It's a 3-jurisdiction project. It's England and Wales, which is one jurisdiction. It's Scotland, which is a completely different jurisdiction within the UK. They have a very different mental capacity regime, and they get very cross when us English people start telling them what to do. And it's also New Zealand, because New Zealand has got some very, very interesting similarities and differences in terms of the approach to mental capacity. So I'll explain a bit more about the project as I go through. But what I thought might be useful, and I'll definitely leave time for questions and discussion, is if I give you a little introduction to how we look at England, how we look at the mental capacity law in England and Wales, give some of the perspective, and then I'd be fascinated to start getting ideas of whether our experiences are similar to things that come across in whatever field you're in, from whichever branch you're in, from your perspective in New Zealand. And then I will shamelessly ask for your help at the end. And you can then decide whether or not to help me, depending on what you've thought of the last 40 minutes. So just a little bit of background. We came to the game later than you. Your Triple PR Act was groundbreaking and was ahead of anyone. Scotland then followed suit. England and Wales came along later. We had a long gestation, starting with the Law Commission in 1991, draft Mental Capacity Bill, then Mental Capacity Act 2005. So we took 14 years from the start of the project to legislation actually being enacted. Subsequently amended to deal with a whole issue called deprivation of liberty, which I won't trouble you with now, but we've spent far too long thinking about now. We, as in the Law Commission in England and Wales, to which I've been on secondment, have now proposed amendments to the Mental Capacity Act, in part to pick up deprivation of liberty, in part to give it a kind of midlife upgrade, to think about things including the Convention on the Rights of Persons with Disabilities, which I can certainly talk about more if people are interested in later. So just to give you an idea of the general structure of the Act, 99% of the way in which the Act is implemented in practice is done without recourse to any form of court. It's the codification, we have the codification in statute in England and Wales of the common law defence of necessity. And as Baroness Hale, our new President of our Supreme Court, who also in a previous life had been the Law Commissioner at the Law Commission, essentially responsible for what then became the Mental Capacity Act. So she has seen this thing through from beginning to now she is pronouncing definitively on what it means. This is how our Mental Capacity Act works day in, day out. Section 5 gives a general authority to act in relation to the care or treatment of P, in other words, the person who said to lack capacity, to those caring for whom who reasonably believe both that P lacks capacity in relation to the matter and it be in P's best interest for the act to be done. It's actually not an authority, it's a defence. So it means that we're not, the doctor carrying out the invasive medical treatment is not committing the criminal act or the civil wrong that they would otherwise be carrying out if they didn't have consent. So that happens day in, day out, hundreds of thousands of times a day, informal care being given. Over and superimposed on top of it, we have a court of protection. I do wish in some ways it wasn't called the court of protection because that makes it sound protective and paternalistically. Much nicer if it's called the court of empowerment. We decided it'd be called the court of protection though. It's a specialist court charged with determining questions in relation to those who lack capacity. Key tasks are to decide, does P have or lack capacity to take the relevant decision? And if they don't have capacity, to decide on their behalf or in their best interests, or sometimes to appoint a deputy, a guardian, to act on the person's behalf. And its other last task, and it does this now quite a lot, is in terms of medical treatment, to say whether or not it is lawful for medical treatment to continue or to be withdrawn. Because we have a lot of cases about serious medical treatment where it's no longer in someone's best interests to be provided with medical treatment. For instance, they're in a permanent vegetative state and the court says it is no longer lawful or it's lawful to withdraw. And it helps, I think, to understand something a little bit about how the court works at a rather more mechanistic level. There are different tiers of judge. The judges who hear most are what are called district judges. They sit in a very informal way. A lot of them are extremely informal. A lot of them spend their time roaming care homes and hospitals because they want to go and see the person. Which always, I had a client where the judge turned up and saw him and the client absolutely point blank refused to believe he was a judge because he was too nice. And this man had had lifelong experience of the criminal justice system. So his idea of a judge is a man wearing a wig, standing up high, sending him to be sentenced, not a nice man coming to see him and asking what he wants. It got me actually because this guy said, all I want is to find a criminal judge who will sentence me because then I can be released. Because he was actually in this care home under what's called the Deprivation of Liberty Authorization, which is our administrative regime to authorize someone to be kept in a care home because they don't have capacity to consent. And so that was one of the most insightful comments anyone ever made about deprivation of liberty, because he said, this is indefinite detention for public protection. Get me before a criminal judge. So 95% of the court's work is actually uncontested applications, most of them on the paper, so no hearing, relating to property and affairs. Appointing someone a property and affairs deputy, allowing a deputy to make gifts, and the person concerned is the party. The default position historically was that the person concerned wasn't a party to proceedings, although normally in contested health and welfare the person would be joined. Still very, very rare for judges to hear from P. Your Triple PR Act has a presumption that the judge sees P, your P, even if that's sometimes honoured in the breach. There really is a working presumption they should see them. Ours, traditionally, judges have not wanted to see the person. There's some fascinating issues about why judges don't want to see people. A lot of it has to do with judges being aware that they are frightened of people with disabilities. And I'm not being funny. If you get a judge being honest, they are genuinely frightened of someone with a disability, especially someone who has challenging behaviour. And they will mask it in different ways. They will say, I don't think it's appropriate. I don't think this is going to benefit them. But actually it's to do with fear, which raises some very interesting questions about the qualities that you need to be a judge here. Our hearings are now, up until very recently, our hearings were always in private, which led to our newspapers calling the Court of Protection a secret court, which goes around killing people and stealing their money. It's not secret, and it doesn't kill people. It doesn't take their money, but the Daily Mail, our main tabloid, hates it. But our hearings are now in public with reporting restrictions. So if you turn up in England and you want to go to Court of Protection hearing, you're perfectly entitled to go along and see what's happening. You may or may not understand what's going on, because most of it is done with skeleton arguments written on the papers, which you wouldn't see. And I've had people come along and say, what on earth was going on there? So that's the structure, but now just boiling down to what are the judges actually doing and what are doctors doing when they're thinking about assessment of capacity, what are social workers doing, what are informal carers. Our Act, a little bit like yours, and very unusually for English legislation, has a set of principles at the beginning. Most English legislation doesn't bother with principles, it just gets straight into the mechanics. So for instance, our Mental Health Act doesn't have a governing set of principles. It starts with what the definition is of mental disorder, and then you go, how about detaining someone? Our Mental Capacity Act recognises that, of course, this applies across the board to any situation. Unless you've got a governing set of principles, how on earth do you come up with something which addresses the complex and extreme range of decisions which could be taken? So we've got our principles, which are really derived from common law, and I think some of these will chime with you as well. First, a person must be assumed to have capacity unless it's established that he or she lacks capacity. English laws like Kiwi law, it assumes that everyone's male, which may possibly mean that no woman could ever be said to lack capacity, but I probably better not go there. A person must be assumed to have capacity unless it's established he lacks capacity. Not to be treated as unable to make a decision unless all practicable steps have been to help him do so have been taken without success. I'll come back to these, but these are the governing principles. And then a person's not to be treated as unable to make a decision merely because he makes an unwise decision. Apparently, this is a very English thing we're trying to preserve. The Law Commission report, which led to this, specifically highlighted the English tradition of eccentricity. So for those of you who aren't English, none of you could ever be eccentric, apparently. So those are the three governing principles which relate to capacity. We've got two which relate to best interests, which I'll come to in a minute. Well, what do we have? We've got a statutory definition of a lack of capacity. For purposes of this Act, a person lacks capacity in relation to a matter if at the material time, so it's time specific. The idea is that you can't write someone off as lacking capacity. You have to continuously think about it. If at the material time they are unable to make a decision for themselves in relation to the matter because of an impairment or disturbance in the functioning of the mind or brain. Which when I taught a course at Auckland University a couple of years ago, a comparative course on the English legislation and the Kiwi legislation, this was an interesting aspect, the fact that we got specific because of an impairment or disturbance in functioning mind or brain in our statute. And we'll come back to that as to how that interacts in England with people who are vulnerable but may not lack capacity. And then Section 3 amplifies the meaning of unable to make a decision. So a person's unable to make a decision for him or herself if they are unable to understand the information relevant to the decision, retain the information, use or weigh that information, or communicate his decision. We don't have an appreciation test, which, for instance, Americans do in some of their competence standards. But appreciation tends to get conflated with using and weighing. We also notice, and we'll come back to, there's nothing there about insight. Those of you who are psychiatrists, or have anything to do with psychiatrists, insight is a very, very well-established, important part of the psychiatric lexicon, but it doesn't appear in here. And I want to just flag that up now because it becomes relevant in a minute. So that's what the statutory test is. There's a very good, quite recent case which sort of boils all this down into 8.5 sparkly, or 7.5 sparkly principles, 8 sparkly principles. Why am I saying sparkly principles? Well, it's a case which got a lot of press coverage in England, mainly from the Daily Mail, because of this woman's sparkly lifestyle. It's a very good case for teaching purposes. I would do lots of teaching of doctors and other professionals, and it's very useful for teaching purposes because it's good, stark facts. So let me just give them to you. C was a woman who was a dreadful human being. I'm not being rude about her. This was the evidence of her adult daughters who said she was a horrible human being. She was our mother. We love her very much, but she's horrible. She had led a completely and utterly self-centered lifestyle. she had had, I think, 2 husbands and several lovers, because every time one of them ran out of money, she moved on to the next one. She completely self-centered, sparkly lifestyle. She gets cancer, and this doesn't fit with C's. This is not part of C's picture. I am not someone who is going to die of cancer having had treatment for leukemia. I'm just not interested in that. So C takes herself down to the seaside, bottle of champagne, and a load of sleeping pills. She seeks to commit suicide. I did once say this was a failed suicide attempt, and I had a very cross mental health nurse saying, it's not, do not call it that. It was a non-completed suicide attempt. She is now in King's College Hospital in London with renal failure. She needs renal dialysis. This is one of those relatively clear-cut cases. If she has renal dialysis, it is very likely she is going to survive, and her prognosis is quite good. If she does not have renal dialysis, she is going to die. It's a good, stark case. And she is saying, no, I don't want it. King's is a good hospital. I'm not just saying that because it's affiliated to King's College London, where I am, but it's a good hospital. They've got good medics and they've got good psychiatrists. They were agitated as to whether this was a spectacularly unwise decision or a decision made without capacity. They get in psychiatrists and they look at her and they say, C appears to have a personality disorder, in particular, a narcissistic personality disorder. I'm a lawyer. I don't understand psychiatry entirely. I'm afraid narcissistic personality disorder always strikes me as this person's doing something weird. I don't like it. I will label it as something. So they said, this is narcissistic personality disorder. So she has got an impairment or disturbance in the functioning of the mind or brain. So tick 1. And she is refusing to accept that she should have renal dialysis, which will save her life. And they are saying this is extremely black and white thinking. This goes beyond unwise decision making into an inability to use and weigh the information that having renal dialysis will save her life. So they put together 2, unable to make a decision because they're unable to use and weigh, plus 2, narcissistic PD, equals 3 or 4 or 5. This person does not have capacity to make this decision. They are a very good treating team, and they recognize that they are on the cusp between, is this person just being bloody minded, and that was the phrase they used, or is this person making an incapacitous decision? And they bring an application to court for a declaration she doesn't have capacity, and a decision that if she doesn't have capacity, a decision that she should have medical treatment. They recognize it's very much on the cusp. An independent psychiatrist is instructed to go and see her. He says he thinks she's got capacity, but he actually does such a rubbish job because he has so little time to do it. Everyone says, thank you very much, and just ignores it. So they've got the treating team saying she lacks capacity, plus a second independent psychiatrist saying she lacks capacity. Her daughters are there saying, this woman, our mother, has got capacity because this is exactly the sort of thing she would do. This is exactly the sort of self-centered decision, entirely consistent with her life, her narrative, coherent structure. The judge essentially does his own capacity assessment on the spot. He doesn't see her because she's too ill, but he goes through all the paperwork, talks to all the people, and says, usefully comes up with the rehearsal of the principles, presumption of capacity, burden, and standard of proof, decision-specific, practicable steps. Merely because the person takes an unwise decision doesn't mean they don't have capacity to make it, and the outcome is irrelevant. Trying to remind people the mere fact that she's going to die if she refuses should not be relevant to the decision whether or not she has capacity. Pre-MCA, under the common law, you had to have a greater amount of capacity to refuse a life-sustaining medical treatment. He's saying that's not true. It's just one test. There must be an impairment or disturbance which renders the person unable to do one of the things, not just more difficult. And then the critical one, the person can't be considered to be unable to use or weigh information simply on the basis they've applied their own values or outlook to that information in making a decision in question and chosen to attach no weight to that information in the decision-making process. And this case turned on that. In C's own life story, where did this decision sit? Was it a decision that she was making without capacity because of her narcissistic PD affecting her cognitive abilities? Or was this just the sort of bloody-minded, self-centered decision that she would always have taken? And the judge said, it's so obvious here, in particular in light of the evidence of her daughters, who were brilliant, because they said, we love this woman. She is our mother. So we are coming at this from a standpoint of interest in her and care about her, but very alive to her flaws. She's completely able to use and weigh the information that she's going to die. She just doesn't care. So that was what turned it in this case. There must be a causal connection between the impairment or disturbance and the inability, and you should consider whether there's a functional inability first. Our Act and our code of practice, we have a statutory code of practice which accompanies our Act, which most people tend to read rather than the Act. The code of practice suggested you looked first to see, is there something with the wrong with the mind or brain? Then ask, is this person unable to take the decision? And this judge actually said, repeating what the Court of Appeal had said a couple of years before, that's the wrong way round. Because actually the Act says, unable to make a decision. That's what you look at first. And it's only if they look like they're unable to make the decision, you have to ask, is that inability because there's something wrong with their mind or brain? And because the judge here said this trust doesn't even get over the hurdle of unable to make a decision, he didn't even have to go into, is this caused by an impairment or disturbance of functioning in the mind or brain? And he said, had I had to go there, I would have required an awful lot of persuasion that this narcissistic PD constituted a sufficient disturbance of functioning in the mind or brain. He is skeptical of DSM-5 and ICD-10, I think, at least there. And then also here, the last point is this is the point at which the English psychiatrists get a bit stressed. Whilst the evidence of psychiatrists is likely to be determinative of the issue of whether there's an impairment or disturbance of functioning in the mind or brain, the decision as to whether or not someone has or lacks capacity is one for the court, because capacity is not a medical construct. It's a socio-legal medical thing of which the judge is the ultimate determinant. So that's a really helpful case for English purposes, for teaching purposes. It's also useful if you want a one-pager, well, not quite one-pager because it goes on a bit, but if you want the paragraphs where it sets out our law, it's that King's College case, and I'll show you at the end. There's a database of all the cases in England and Wales which we produced, or almost all the cases where you can find it, if you want to get an English summary. We also did, because people kept asking us in chambers, how should we do a capacity assessment? We wrote a guide to carrying out capacity assessments. Because we as a barristers' chambers are very worried about the legal literacy of health and social care professionals because they just don't get enough training in England. It may be different here, but I'm not completely sure it is. And I know Alison and Greg had drew on this a bit for some of the toolkit that they've produced for New Zealand. Just to complete the picture before I come back to the project or some of the case law, just finally to complete the picture, if someone lacks capacity, we are then into best interest territory. And we've got the two governing principles. The first isn't really very interesting. An act done or decision made under this act for or on behalf of a person who lacks capacity must be done or made in their best interest. The really important one, which I always call for training purposes, the Spider-Man principle, is this one. Before the act is done or the decision is made, regard must be had to whether the purpose for which it's needed can be as effectively achieved in a way that's less restrictive of the person's rights and freedoms of action. Why do I say Spider-Man? Well, Spider-Man, great power. With great power comes great responsibility. Because the really frightening thing about the Mental Capacity Act, which is a brilliant piece of legislation in lots of ways, the really frightening thing is it's incredibly easy to do someone in on the basis of lacking capacity and then do what you want in the name of their best interest. And it's only in all the cases where things have gone wrong, it's because people haven't stopped to think, to go, what am I worried about here? Is there a way in which I can secure this person's well-being in a way that is less draconian? And there are strings of cases where people have waded in. And what gets me personally is that it's then said to be a decision made on behalf of that person in their own best interests. I mean, John and I were discussing at lunch about dignity, about the objective versus subjective definition of dignity. It seems to me more insulting to say to someone, I am going to do something you absolutely do not want me to do on your behalf and in your best interests. That is deeply insulting. Compared with our mental health regime, which doesn't even pretend to do things in their best, for someone's best interest, says, I need to do this to you because I, as a medical professional, a social worker, think I need to do this to you to secure your well-being or to protect someone else. I mean, if it's done right, it's great. But it's a very, very, because it's so nebulous, it's a very dangerous piece of legislation when it's in the wrong hands. I mean, I love it. I'm a fan of the Mental Capacity Act, but it's a very dangerous piece of legislation. And so it's a bit small, but I'm very happy, by the way, these more than happy for these slides to be circulated by email. But our mental capacity test for what's in someone's best interests isn't an algorithm, because it couldn't be, because this applies across the board to any decision which could be someone could lack capacity to take. So you can't plug in a set of facts and come up with one answer. It's always, you have to take into account a range of factors. And then, as I said at the bottom, it can't be emphasized enough, Section 4 never gives the answer. It just makes people ask, hopefully, the right questions. And because this is all predicated on reasonable belief, at least outside the courtroom, it's a recipe for endless argument as to what is in someone's best interest, because you can easily go through and conscientiously apply the checklist and come up with a completely different view as to what's in someone's best interests than your colleague across the way. And the stereotypical thing that happens is in multidisciplinary settings, the psychiatrists have one view of risk, social workers have another view of risk. And you get an interesting tension there. I always think it's a very good point at which to take stock and say, why have I reached these different answers? Let's have a discussion and let's work out which values I'm bringing to the party. What quite often happens in the more heated scenarios is it's someone with a particular title after their name, or a particular set of letters, or a particular colour of coat pulls rank. But that's how it goes. Our capacity, mental capacity Act sets the framework for almost all types of capacity, but there are some common law tests which continue to have effect in other areas. There's a common law test of capacity to contract, gifts and testamentary capacity, although the Law Commission very recently has proposed to extend the MCA test to testamentary capacity, because no one can work out why doctors are applying one test to work out if the court should be making a statutory will, court of protection, but a completely different test to decide if someone had capacity previously to make a will. Is completely incomprehensible. The other bit which people really didn't think about and has now become very important, or increasingly important, is this. I said a person lacks capacity in relation to a matter of the material time they're unable to make a decision because of an impairment or disturbance in the functioning of the mind or brain. What we've realized is that there's a whole cohort of people who exist out there who absolutely have capacity in ideal circumstances, in the sense that they don't have an operative material disturbance in functioning of the mind or brain, but they don't appear to be able to make a decision. And the reason they can't make a decision is that they are vulnerable and they are being constrained. They're under undue influence. They're the people who the doctor talks to the patient, and every time the doctor talks to the patient looks across to the family member who's sitting in the unit with them. And then the doctor says to the family member, would you mind leaving the room, please, because I really need to talk to my patient by myself. The person leaves. And every time that the doctor asks the patient the question, the person looks through the door to where they know the family member is. And legally, they are a completely different group of people to the people falling under the scope of the MCA. So we've now realized that there are three cohorts of people. There's the capacitous non-vulnerable, i.e. allegedly the people in this room. I won't make too many assumptions. I'm still quite jet lagged, so I'm not sure which one I put myself in. Then we have the incapacitous, and then we have the capacitous but vulnerable. And what the Court of Appeal confirmed in 2012 was, we are not going to let this last cohort of people just slide. Because there was an argument that Parliament had decided there is the world of the incapacitous, which by definition means everyone else is capacitous, we can't touch. Court of Appeal said, we're not going to go there. That's wrong. We are going to say there is this great safety net which exists in respect to this cohort of people. The million-dollar question is, how far can the court go? Because High Court is exercising its inherent jurisdiction. In other words, the High Court's ability to do whatever it wants, so long as it's not stopped by a statute or by a higher authority. How far does it go? Is it limited to saying, I'm going to tell the family member to leave completely, so that the doctor or the social worker can talk to the individual themselves? So facilitative. Or can it, as some of the more high-octane judges seem to think, can it actually say, I'm going to take a decision on behalf of this person, this vulnerable person, and grant relief directed against them? And that gets very fruity at that point, because if you think about it, a judge has suddenly, I mean, there was a case where the judge said, I would have been prepared to order that this woman live apart from her husband, who she's been in a codependent, hopeless relationship with. And I think it's more important this woman is safeguarded by staying apart from her husband, even in circumstances amounting to a deprivation of her liberty, even though she's got capacity. And at that point, you go, well, why do we bother with any of this Mental Capacity Act business anyway? Because by definition, everybody who falls under the MCA is going to be vulnerable. And so there's a big lurking issue. I'm trying to persuade our Law Commission to do a project on this, to actually define the boundaries and to think about what vulnerability looks like nowadays. And what does it mean in relation to, for instance, the Convention on the Rights of Persons with Disabilities? Because anyone who's interested in the CRPD knows that some people say we should not have any form of capacity. Mental capacity is inherently discriminatory. It should be abolished. And some of them have said the way to get around this is to say the only sort of jurisdiction which should exist is this, because it's non-discriminatory. It's not based on disability. It recognises any of us at any point could be vulnerable. Speaking personally, that frightens me enormously, because that means anyone could be subject to a High Court judge in England telling them to do what to do. To which the counter argument is, good, if that frightens you, that means we should think more closely about why we're happy to have one cohort of people who we say have got disabilities being singled out for this particular form of treatment. But anyway, I want our Law Commission to think about that. So we are, as Alison said, we are thinking about the future. We've suggested, and I say we because I'm on secondment there, although I'm not speaking on behalf of the Law Commission, we've suggested amendment to the best interest test, in particular to prioritise the person's wishes and feelings. And essentially say, if you know what the person would have done, you make that decision, unless you essentially have a good reason not to. I mean, that, frankly, doesn't really need anything other than that's just blindingly obvious common sense and basic respect. But apparently that's, in some circles, a bit controversial. We want to restrict the Section 5 defence to recognise that a lot of what goes on under this informal decision-making regime is incredibly high-end stuff. It's carrying out serious medical treatment against someone's wishes. It's stopping contact. It's moving people from their own home into institutional care. This is high-end interference with people's rights. And that's being done purely on the basis of a reasonable belief in lack of capacity, reasonable belief in best interests. We've said we need to make sure that that Wild West is tied down. And so we make it an uncuddly thing that, and if you haven't carried out certain procedural steps, including actually supporting the person to take their own decision and recording why you haven't been able to, there is no defence, which would then mean enthusiastic lawyers will have to bring a number of claims and to frighten NHS trusts and local authorities' insurance departments. Because the government won't give any money to pay for more advocacy services or anything which looks like it costs money. So the only way to achieve this form of protection is to remove legal cover. And then the challenge that the CRPD I've already mentioned, the very idea, at least in some quarters, of an idea of mental capacity is anathema. I've written an article about why I think, with the greatest respect, that is incorrect. As this has been recorded, I'll use that term. If it was not being recorded, I might use slightly stronger language, which I can point you to if you're interested. So, bringing it closer to what we're doing, or why I'm here, we've got the Wellcome Trust gave a big collaborative project called Mental Health and Justice a substantial chunk of money to run for 5 years, starting from January of this year, to do a range of projects under the umbrella title Mental Health and Justice, which include, for instance, looking very hard at the role of insight, looking at objectivity in evidence in relation to mental health treatment. A very interesting project on metacognition. There is some very high-end work being done with fMRI scanners, which suggests there may be some ways in which you can identify capacity, if metacognition, i.e. an understanding that you know that you are thinking, as a proxy for capacity. Because one of the big charges against mental capacity is it's all completely subjective. There's some work being done, so there may be some elements which are actually objective. There's also a project, one of the work streams is on, for instance, bipolar disorder, people's ability to make so-called self-binding directives, to say there will be periods I know I'm unwell when I want to be treated in a way which looks to the outside world like it is coercive, but actually this is what I want. And I know that if I'm not treated coercively in this fashion at an early stage, the consequences for me will be much worse. So please treat me early and coercively, which is a project which is going to try and actually come up with actual self-binding directives in one particular mental health trust in London to try and give it a really good shot. And then the other one, and which is the one I'm here to talk about, is this one, which is on contested capacity assessments, on hard capacity cases, which it's in part driven by a feeling that it's very difficult to answer the challenge of the CRPD that mental capacity is all entirely made up, without a better series of approaches to say, no, it isn't, or if it is all made up, at least is made up in a way which is satisfactory. In other words, sort of replicable, or at least allows answers to be given in any given case which are defensible. And it comes from, it's a psychiatric and a legal collaboration, in the sense of it's led by Dr. Gareth Owen, who is a psychiatrist at King's, very, very good psychiatrist, me, barrister, and then Dr. Scott Kim, who is a psychiatrist and an ethicist at the NIH in National Institutes of Health in Washington. And then we're getting a clinical fellow in as well. And we want ultimately to produce educational materials which can be used by psychiatrists, which can be used by lawyers, also possibly by judges. We want to equip judges with tools to sit down and think about being more careful about when they're thinking about capacity assessments. It gets quite twitchy when we're talking to judges in England and Wales because they don't really like being told what to do. However, the more honest ones realise that they're quite often unleashed on cases and circumstances where they are not absolutely sure what they're meant to be doing, and they're also not equipped with the tools to ask the right questions of the people who are talking to them. So how are we doing it? Well, what we're doing is we're collecting data on hard or contested capacity cases in 3 jurisdictions, England and Wales, Scotland and New Zealand, which is an analysis of all the published court judgments. We have quite a lot of court of protection judgments now published in England and Wales. I think there's about 80. There's 3 in Scotland. Scotland published disappointingly few cases, given their Act came along in 2000. I'm still hoping to get some unpublished ones. I'm going to actually rely shamelessly on your work, Alison, the very, very good analysis you did at the end of your New Zealand Law Foundation report in relation to the Kiwi cases. But we're going to be doing some of original work on some of the Kiwi cases where they shed light on things that you've encountered that we haven't encountered in England and Wales, because you've got an awful lot of cases which sort of routinely say the same thing, which don't necessarily add all that much value to the project, simply because you've got a body of case law which is built up.
Not very much published.
Not very much published, no. And the published ones tend to be very, very short and tend to just apply, read Tony and say, here we go, off we go. And that doesn't add to a typology of cases, because what we're trying to come up with is a typology of hard or contested cases, looking both at what are the sorts of cases which are problematic, i.e. what sort of issues cause problems, and then also what is it within those cases that cause difficulties. Is it understanding? Is it retaining? Is it communicating the decision, or is it using and weighing? Why is it that some aspects are more difficult? With a view to developing and evaluating initially by way of a pilot project, and then we'll seek additional funding to get a bigger scale project up and run, educational materials. In part to do things like try to make sure that if you're sending someone off to go and assess capacity of someone who has dementia, they are equipped with tools to ask meaningful questions of somebody with dementia, which is very different to asking questions of someone with an acquired brain injury or with profound depression. Because at least in England and Wales, there are endless numbers of tools which say, this is what the law is, go and apply it, which is completely unhelpful for people who are actually trying to translate that into talking to an actual human being. And there's a real bit missing in the middle. So that's what we're trying to do. Why are we doing it? As I say, to help clinicians in particular work through hard capacity cases confidently, to help ensure that capacity cases that get to court actually need to be there. And actually, I'd add a third one, which is to ensure that when we do get capacity determinations, they are satisfactory. It's the only word I can really come up with, or defensible, in terms of this is actually making the use of language and the use of ways of which to explain you've reached a conclusion which actually stack up. Because I have been deeply concerned going through, and I'll get to this table in a minute, which is what this is my capacity report assessment template for going through all the call to protection cases, deeply concerned with when it gets to our call to protection, how judges are finding difficult to explain why they've reached conclusions. And if judges are finding it difficult to explain, that means I'm slightly worried, because that's supposed to be the kind of ultimate determinant. So just a couple of preliminary findings just to relay to you, and then I want to throw it over to you. Emphasizing a few things: the causative nexus. In other words, this idea, this recognition that you can't put two, someone appears to have something with their mind, wrong with their mind or brain, together with two, they look like they're unable to do one of the functional things, and come up with five, which is that they lack capacity. How is it that you actually find out that someone is unable to make a decision because of a lack of an impairment or disturbance of function in the mind or brain? That's that PC and NC case. We've got ourselves into a massive tangle in England and Wales about sex, probably because we're English, and that's the sort of thing which we get stressed about. But both sex and contact, we get terribly stressed as to whether it's act specific or person specific. And the courts, in particular in relation to sex, has said it's act specific. You don't ask, does someone have capacity to consent to a particular sexual encounter with another person, with an identified other person. You ask, does the person understand at a very rudimentary level the mechanics of the sexual act? And if they are a woman, the potential that they might become pregnant. If they do, you don't start asking questions about who they might have sex with. Which is interesting at a number of levels, not least because Lady Hale, in a different context, has said you can't think of anything more person-specific than sex. You don't consent to sex in the abstract. You consent to have sex with somebody at this point, with this particular person at this point. And the courts have taken a very pragmatic view, saying, no, we don't want to go that line, because that means someone with, for instance, a mild learning disability, as we call intellectual disability, we'd otherwise have to follow them around continuously, assessing their capacity to decide whether or not to have sex with particular potential partners. We don't like that idea. Judges get round it, though, by saying, you know what, we think contact is person-specific. So you can make a decision as to whether or not someone has capacity to have contact with person A. So we'll say the person has capacity to consent to sex, but they don't have capacity to have contact with person A when we know that they're very likely to have sex with them. So we'll do them in that way. You can see judges, I mean, I'm being rude about the judges, but they're confronted with real problems and they're trying to find coherent ways round. To my mind, that's not a very coherent way round, but that's what they've done. The other thing which we have huge problems with is fluctuating capacity. Not someone with a raging urinary tract infection who you just treat and know will recover. That's easy. It's the person with bipolar who properly fluctuates. How do we deal with it? The courts aren't great. They go, we don't really know what to do. And that's that A, B, and C case, where the judge basically said there's some sort of decisions like managing property and affairs, which are really made up of multiple mini decisions all the way through, and therefore I can do someone in, even if they've got periods of lucidity. And that's just a very pragmatic approach. Doesn't actually fit with what the Act is telling, but I completely understand where they're coming from. So looking just at this case template briefly, some of the things which have really worried me, because I've gone through and this is what I came up with, and then I've gone through all the cases, and I think I've now done 80 of the things. We've identified nature of issue, reason for selection. The bit which really worried me was over the page on, actually, bottom of page 3. Sorry for those of you in Wellington who don't have it. At the bottom of page 3, there's a box saying functional deficit relied upon as giving rise to incapacity. And you can see 1, inability to understand relevant information, 2, inability to retain, 3, inability to use and weigh, 4, inability to communicate decision. I had to add, about 20 cases in, a new box, which was no specific deficit relied upon. These are people who have got to the point where a judge has made a final declaration under the Mental Capacity Act that they do not have capacity to decide, make a specific decision, and there is no specific functional deficit identified, which is, to my mind, deeply, deeply troubling. I'm sure that if you sat down with the judge and asked, what was it? Understand, use, weigh, retain, they'd be able to tell you. But if this is the record which says why we are allowed to do this, the fact that I had to go and add this box in, because initially I was trying to find increasingly clever ways of saying, I think it must have been that they were relying on this. I went, no, that's just dishonest. That is deeply troubling. The other bit which is troubling is that main troubling is there's very, very little reference ever as to, under box F, consideration by court of practical steps taken to support P to make the decision. Very, very little reference ever to the court going, what was actually done to try and support the person to take their own decision. It goes almost immediately into, I accept this person doesn't have capacity, what do we think is the right thing to do? And then very rarely is there ever consideration of the causative nexus. Partly that's because the courts only recognised about 5 years in that there was such a thing. But even then, there's very little reference. And the other thing, which is, I can't in some ways do the judges in too much to this, but it still does worries me. Box N, outcome of events following the court's judgment. 1, recorded in judgment. 2, another source. 3, not known. Almost in all of them are 3, not known. We just don't know what happens. Some of the medical treatment cases, the judges have a postscript saying the cesarean section happened, the person died, the whatever. But it strikes me as very problematic that you've got judges making decisions, huge substantive decisions about people, and you've got no idea what happens. The judges, when I push them on this, actually quite a lot of them get very agitated and push back and say, we don't want to know, because we are called in to do one specific thing. We do not want to have our decisions biased or be afraid of what we might do in future because we're worried about what might then happen afterwards and have it infecting back, which is not entirely illegitimate, but it's very odd. And every teaching session I do, I'll do one of these cases and someone says, well, what happened? So I have no idea. Or I happen to know because I was told by someone who shouldn't have told me and I can't relay it on. So there is some interesting stuff there. Reverse engineering the protective impulse. It's absolutely obviously the case that the correlation between person agrees with course of action that grown-up suggest is sensible, has capacity, person doesn't agree, person lacks capacity, especially where it's a risky decision. People naturally go into the caring professions because they want to look after people. It's very, very difficult to escape from this, very difficult. The use of insight, I've specifically highlighted that does not appear in the Act. The number of cases where insight is used, either by the psychiatrists, because it's language they're used to, or even when the psychiatrist hasn't used it, the judge says this person doesn't have insight. You go, well, hang on a minute. Could you please translate that into the language of the law? Then the last one, this is fairly obvious. Use and weigh is the danger zone. It's pretty easy to work out if someone can understand information. It's pretty easy to work out if someone can retain. It's fairly reasonably easy to work out if someone can communicate. It's incredibly easy to do someone in subjectively on the basis of using and weighing. Because apart from anything else, I can't judge if someone can use or weigh information unless I assess it by reference to how I use and weigh it. If someone uses and weighing it differently to how I do it, by definition, I'm the reasonable person. You're not using and weighing it in a reasonable or rational fashion, ergo, they don't have capacity. The slippery slope is instant, if you can have an instant slippery slope, you see what I mean? And that's one of the things we are really wanting to get at in our typology and our educational tools eventually. It may well be that it's simply impossible to train people out of it, but at least we can give more transparency. So why take part? Well, psychiatry meets the law in a crucial and developing area. Even if mental capacity gets shot out of the water by the CRPD, we're still going to have tools for asking what support does someone need to exercise their legal capacity. And that is, frankly, capacity assessment by any other name. A chance to contribute to research or practical outcomes, not just for you or your colleagues, but lawyers and judges, help shape the law as well as clinical practice. If you want to take part, or anyone you know wants to take part, we're doing interviews in 2018. They will be by Skype. I'm due to come over here, but not until 2019. And then those are the contact details, which are also on the sheet. That's me, Alex Ruck, Keene at 39essex.com. And Gareth Owen is gareth.1.owen@kcl.ac.uk. That's our mental health and justice. Lastly, the newsletter, which if you're interested, we do a newsletter in Chambers. Printed out a couple of copies of, which is free. It comes out every month, or there's a break this month because I'm not in England, which covers our mental capacity case law. It's got all the cases I've talked about. You can find for free, searchable database, because we're very worried about legal literacy generally. It's at 39essex.com, resources and training /mental capacity law. So over to you for 10 minutes. of questions, discussion. Please can everyone tell me it's all perfect in New Zealand, so all we need to do is implement the Triple PR Act and we can all go home. I think that may not be the case, but I'll be optimistic.
That's absolutely fantastic. I think we'll just have a quick round of applause. And I was going to say to Alex that we've got it all sorted. Not. Just a little postscript before we get on to questions is that for the non-lawyers in New Zealand, our Triple PR Act has a similar test based on the common law. So we share the similar functional test to England, but it speaks in the language of saying whether the person understands the nature and foresees the consequences of the decision. So, but what we can say is that we, because we share the common law, that essentially, although it's worded differently, we use a similar test and, of course, similar legal principles. I just make that point because we've used the Mental Capacity Act test, the functional test about understanding, retaining, use, weigh, or communicate in our toolkit because we see it as a really clearly laid out piece of law. And interestingly, under the Substance Addiction Compulsory Assessment Treatment Act, which will come into force next year, a compulsory care and treatment law, it has introduced that the English functional test. So that might be a way of sort of sharpening our law, in fact, to make it sort of a bit clearer. But I'll just sort of put that in there, just if you were wondering. But so different language, but essentially the same sort of themes and concepts.
Which is absolutely one of the reasons we wanted to use New Zealand as a jurisdiction, because we've got the underlying similarities, even if sometimes they're framed in slightly different ways.
But I hate to disappoint Alex, which is I don't think we've got as much case law as he would like to see, all these amazing cases in the Court of Protection where really in England they really are unpacking the law. So, and there's such a lot of judicial reasoning that goes on, which is really, 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 really interesting to follow. Okay, questions. So,
I don't understand what work the nature of conditional life fine is giving rise to dispute. I don't understand what work that does. I've wondered this for a long time. So it seems to me as though whether someone has a diagnosis of a condition or not, you have to assess capacity. So I don't get what work that does to say that someone has a diagnosis.
That's a very good question. The reason specifically for this, the reason we've got this in is we're interested to know how many people are coming before the courts who have got, say, chronic psychosis or whatever, what it is, the cohorts of people who are being identified as potentially lacking capacity, because we're wanting to know, are there a disproportionately large cohort of people with dementia, say? But
so then we have serious implications for people who are diagnosed as having, say, a mood disorder, because they might think, oh, now I probably can't get a job that requires a high capacity, because the assumption is that people with these sorts of disorders have high levels of capacity. I get that's not what, but just in terms of what it's doing.
Yeah, I mean, well, ironically, the reason why we've got a specific diagnostic test, I mean, the reason why we've got this bit, because of an impairment or disturbance, that was put in the Law Commission. I mean, the Law Commission put that in specifically to try and narrow down the reach of incapacity. Because they said if we didn't have that, I mean, this is now reasoning which is 180 degrees the other way around, people challenge. But they said if we don't do that, capacity is far too wide. We can do too many people in. So well, that's why the CRPD says, let us not have anything which relates to any form of disability, because the challenge is if you've got a particular, I mean, the one which gets, someone with schizophrenia, I mean, there's the court protection case where the judge walks in and says, this person's got schizophrenia. Of course, they don't have the ability to make decisions about their birth plans. Luckily, everyone in the courtroom went and said, hang on a minute, that only gets you one part. And actually, the other thing is it's not a diagnosis. It says impairment or disturbance in the function of the mind or brain. So
that's possibly a moot point. But so in New Zealand, ironically, so we don't have they call it, quote, diagnostic threshold, which Alex probably wouldn't agree. So we're not discriminatory in terms of the CRPD, the Convention on the Rights of Persons with Disabilities. But on the other hand, in New Zealand, there's probably a wider net that doesn't meet threshold because we only have a functional test. So it kind of goes both ways.
I mean, it really depends on what you want, which is one of the reasons I want our law commission to think about this vulnerable adults business, because you don't have, on one view, you don't have the vulnerable adults problem.
Well, but I would argue we have a low threshold called partly lacking capacity. When I gave a similar seminar to, as Alex gave today in England, they laughed at me, and I said, well, that's how a court, in the family court in New Zealand, a Section 10 order, personal order, you only need partly lack capacity. And so, you could say that we actually catch the vulnerable adults.
Yeah, you do.
In that sense. So we actually probably have a wider net, arguably, under the Triple PR Act. Is there anybody in Wellington that wants to ask a question? Sorry.
Yeah. Oh, I do. Hi, Alex. It's Giles here.
Hi, Giles.
And I work in a personality disorder service. But all that said, I wonder if you're considering CRPD and the concept of there being no substituted decision making. If chasing a functional path is doomed to failure, and actually what we need to be doing is chasing a path which recognises the values of a person as the basis for deciding whether they're making sensible decisions according to their own values, which kind of looks even in the King's case.
Yeah, no, absolutely. And on one view, the more you place weight in the best interest decision-making process on the values of the person, the less interesting the divide between capacity and incapacity becomes. So you then get to an outcome where you, by and large, are supposedly making a decision that the person would have wanted. And the sting of incapacity becomes much less. Obviously, you're still doing it from this person is allegedly the other side of incapacity. So it's not a decision being made in their own name. It's not a decision being made by them. It's being made in their own name by somebody else. So yeah, and one of the things I'm really interested in on the bipolar disorder, also the bipolar self-binding directive stream, is we are saying we want to have people being able to contribute to their own capacity assessment, because we're saying we want people to be able to say, when I behave in this fashion, I know from previous experience, I do not think I have capacity to make my own decisions. Please, could you take this into account when you are looking at me at this point? Which I think is an interesting way of looking at it from a CRPD perspective. Because unlike an advanced care plan, which kicks in when the person's said to lack capacity, this is actually getting into, is this person within their own definition able to make their own decisions? But yeah, obviously we are to some extent defending a completely indefensible model within the scope of the MCA.
But interestingly, just on that, Giles, there's also the Essex Autonomy Project, and Alex has been part of those projects as well. We're sort of saying things like advanced directives and supporting the making of enduring powers of attorney. These are all part of, a regime that sets up supported decision making, because it's essentially encouraging people to, exercise their will and preference, as it were, while they can, should they no longer be. So
yeah,
we do actually have a Bridget, just quietly in the corner. Just Bridget Murphy-Veach has written and done a lot of research around the CRPD in New Zealand and disability rights. Bridget, have you got sort of any comment about abolishing substituted decision-making regimes?
Yeah, I'll be one of those people who use stronger language now. I've been saying here quietly. So I guess I'm not a researcher in the disability area, and certainly as a CRPD. So I'm really here and done some work recently where we looked at what the MCR is saying around this issue, or some of the.
We can't hear you.
Sorry.
Oh, so Bridget, can you come a little bit closer? Yeah. Hi, John.
Other jurisdictions to address this. I really
sit up. Yeah.
So essentially, I'm not a psychiatrist or I'm not a clinician. I'm a sociologist by background, and sort of work a lot in the disability community. So I guess when I'm sitting here thinking about these issues, I'm thinking, just keep coming back to that notion of will and preference.
Absolutely.
And that a lot of the contentious issues and a lot of the difficulties, in my very unsophisticated view, I think can be ameliorated to quite a large extent by really, really focusing on that issue of will and preference.
I couldn't agree more. I mean, that's one of the reasons why we have said we think it should be on the best interest side. It should be that if you can identify the person's wishes and feelings, which we are saying is the proxy for will and preferences, there's obviously a debate about whether that's right, that should be the decision which is followed. So I think that does ameliorate a lot of it. Obviously, it doesn't, though, ameliorate it from the perspective of it is still ending up being a decision made by somebody else. That's right.
Yes, but I think the positioning of it is slightly different if you take the UNCRPD of will and preference as opposed to best interests with a focus on feelings. I think if you, so that's just my view. I am one of those people, but
Well, I love all of this stuff, and of course I'm here to stay for the afternoon, but we are going to have to actually move on. So, but thank you, Bridget. Hopefully we can continue the discussion. Just on behalf of Jing Bao, who is actually the host here, and everyone here, thank you very much, Alex, for a really, really interesting talk, and we hope you continue your contact with us here in New Zealand. Okay, thank you. So when we do have a few local lawyers here, I don't know if there's anyone can say.
Oh, pleasure. Oh, pleasure.
Screens are being circulated by email.
That's probably why I think.
Hi.